If you were sued today, what could they actually take from you? That's our conversation for today. If you or your business, this conversation is for entrepreneurs, operators, business owners. Welcome to Free Law School. My name is Gregory Swafford, and the question is, if your business was sued today, what could they actually take from you? The answer is going to surprise many of you. It's going to surprise many business owners. We're going to get into it. We're going to talk about what limited liability protection is, how it operates, and why many business owners are actually operating under the illusion that there is limited liability protection, that their assets are actually protected, when in fact there is exposure. Let's talk about what limited liability protection actually is and how it works. The reason that we form LLCs, we're going to keep the conversation on LLC, even though the limited liability protection works the same way for the corporation. There is no distinction. There's a lot of misinformation out there that the corporation provides greater protection than the LLC. That's actually not true. It works the same way. Limited liability protection operates the same for the LLC and the corporation. It is absolutely necessary that the business owner separates his or herself from the business. And how is that done? That's done by behavior. So, limited liability protection. When you form the LLC, the purpose behind doing so is to separate your personal assets from any business liability. That's your home, your vehicles, your bank accounts, retirement accounts, salary if you're still working, if you're operating the business as a side hustle. Those are your personal assets. Many business owners believe that merely forming the LLC provides protection and that the paperwork that results from filing is actually evidence of that protection. That's not true. There is no protection in forming an LLC or in the paperwork. Formation of the LLC is simply the creation of a container, a box from which the business operates. Whether or not there's going to actually be limited liability protection in the event of a lawsuit depends upon how the business operates going forward. Now, let's talk about the purpose, the real purpose behind forming and the benefits of forming the LLC. It serves to separate, create a shield between those personal assets and any harm or injury that the business might cause. Now, that protection, that protection is specific to your personal assets. Now, when business owners form, there are also business assets. The limited liability company, the LLC, provides no protection for those business assets. That's going to be things like your real estate, cash reserves, business equipment, accounts receivables, intellectual property. All of those things exist inside the business in most businesses. And the reason that those assets exist inside the business is because many business owners never give any consideration as to whether or not the valuable assets should be separate from the operational risk. I'm going to say that again. Most business owners never give any consideration as to whether or not they should separate the valuable business assets from the operational risk. That's why we say many times that most businesses are formed backwards. That's the unfortunate reality. Most businesses are formed backwards because the first thing that the entrepreneur, operator, founder thinks about in creating the business is that I should form the LLC. I should get an EIN number and then open a bank account. And after that, it's off to the races. Let's generate revenue. Rarely, rarely does the business owner give any thought prior to forming the business, any thought as to where those assets should be located. And so what ends up happening is that most business owners only form that one entity, the LLC. And inside that LLC is their personal lives in many instances, as well as the business assets. And then they think that there's total protection. That's one of the biggest lies and greatest misconceptions in business for the entrepreneur. That once you form the LLC, everything is protected. That's not so. The LLC's purpose is singular. Its purpose is to protect the personal assets. And that protection is conditional. It's conditioned upon how the business owner operates the business. Is there a separation between business expenses and personal expenses? You may have heard the term commingling. Hello. You may have heard the term commingling before. Are the expenses kept separately? How does the business owner sign contracts, invoices, all of those things? Are they done in the name of the business, or does the business owner lapse in and out of signing things in a personal capacity on occasions, as opposed to the business capacity based upon the business? All of those things, each of those transactions send out signals. Every time you do any of those things, a signal is being sent out. And that signal is going to be used to classify the business at some point in the future. Now, here's the problem for your personal assets or your business assets. Those business assets located in that LLC, titled in the name of the LLC, and used to operate the business, have absolutely no protection. So when the lawsuit is filed, a claim is filed against the business, and if that claim results in a judgment, those assets, business assets, the things that you rely upon every day to run the business, those things become immediately reachable. The LLC provides no protection for them. I need you guys to understand that. I need you to understand that. There is absolutely no protection for the business assets. If you're operating out of a single LLC right now and thinking that not only are your personal assets protected, but also your business assets, you are mistaken. And there is immediate exposure. Now, there is a real possibility that both your personal assets as well as business assets are exposed. And again, that is based upon how you operate. If there is no separation between your personal and business transactions, if there's commingling of the funds, if the owner acts as guarantor on behalf of the business, then those signals are going to be picked up and read as personal by institutions. And look, on a daily basis, businesses send out signals to institutions unbeknownst to the owner. Each of those transactions, think about your paperwork, all the things that get signed, everything from your formation documents, all of those things send out signals. They're part of the historical record. So when the business engages with an institution, that could be banks, when you apply for loans, loan applications, those all of your business documents come into play. If we're talking about lawsuits, those documents are interpreted at that point in order to classify whether the business can operate, whether the business actually operates independently of the owner or whether it's personal. Because when we're talking about litigation and the seizure and sale of personal assets to satisfy a judgment, that's what the analysis is about in court. Once they determine who's at fault, the analysis shifts as to whether or not there is the personal assets are going to be at risk as well as the business assets. And the other side at that point is trying to poke a hole in your corporate shield. They want to demonstrate that, in fact, the business has not been ran independently of the owner, that the business is actually dependent upon the owner. And if the business is dependent upon the owner, then the court should allow the judgment creditor, the person who sued your business and won, the court should allow them to seize any assets in your name in order to satisfy that judgment. Now, that's assuming that the business owner does not satisfy the judgment outright. If the judgment is not paid, then they move into the execution phase on the judgment. And that's where your business structure actually gets tested. Now, there's a lot of misinformation out there about business structure online and on social media. Content creators have co-opted the conversation regarding business structure and placed it in all kinds of contexts that absolutely have no bearing upon what business structure is really about. Those conversations range from everything from structure your business in order to get a credit funding and a stack of credit cards. Let's structure your business so that you can receive grant funding. None of those things are about business structure. Business structure has three basic pillars. It's about asset protection. That's the conversation about protecting your personal assets from business liability. That's one layer. The second layer is protecting your business assets from operational layer. And if you're operating a single LLC, that's it, and all of those assets are located there, the business assets are exposed right now. That's the asset protection phase of business structure. Business structure also is about tax efficiency. What we form, what entity we form, has a bearing and an impact on how much taxes you pay. That's business structure. And the third and most overlooked pillar of business structure is continuity. What happens in the event that the owner steps away from the business? It could be becomes ill, incapacitated, on an extended vacation, or maybe even death. Is there written authority on how things will go forward? Does the business have to go through probate in order to liquidate the assets of the business, if that's the move, or to continue the business? Who has that authority? Those are the issues involved in business structure. And the purpose of this conversation is to make business owners aware that many entrepreneurs, operators, founders are laboring under the misconception that there is protection and that the protection came from merely forming the business. Here's some of the things. Let's talk about some of the things. I'll give you some examples. Some of the things that send out those signals that the business owner transacts on a daily basis, but nobody's really looking at that time. The institutions only analyze those signals in order to classify the business when we apply for a loan, if it's at the bank, if we're applying for business insurance coverage and wanting to cover those assets inside. The underwriters want to know, how are those assets titled? If we're engaging in a real estate transaction, the real estate underwriter wants to know how the assets are titled prior to giving the clearance to close. If it's litigation, the court wants to know, how does the money move? Who stands to benefit? Who absorbs the risk? Who has the authority to make binding decisions on behalf of the business? How were the transactions signed? And all of those things are historical. Each institution, banks, underwriters, courts, investors, they're all reading those signals at that time. And those signals may have been sent out by most businesses years ago, depending upon how long the business has been operating. That's what we mean when we say that when we form the business, that's only a container. And whether or not there's going to be protection is to be determined in the future, to be determined by the reading of these signals, or those signals that the business has been sending out for the duration. That's what determines whether or not your personal assets are going to be safe. And even if the personal assets are safe, the business assets are exposed because they exist at the operational level where the risk lives. The risk lives at the operational level is because that's where the business encounters the public, clients, vendors, partners, employees. That's where the potential risk lives. And if your assets also live inside that single LLC, then those assets are exposed. If there's actually no separation between the business owner and the business, meaning the business owner does not respect signature protocols, signs on behalf of the business in his or her personal capacity, acts as a guarantor for business transactions, pays personal expenses out of the business account. Then there is no separation. And where there's no separation, the liability goes both ways. So imagine for a minute that someone sues you in your personal capacity. You own a business. Someone sues you in your personal capacity, has absolutely nothing to do with your business activity. But because there is no separation between you and the business, then your business assets are exposed for satisfaction of that personal judgment against you. So it goes both ways. That's why separation is so important. And even the urgency exists for the business owner to really understand how to operate, how to move, how to sign things, how to move money, all of those types of activities that are conducted on a daily basis. You're doing those things every single day. That's how you avoid the liability. And so, no, formation and paperwork alone, it doesn't do it. And I know that these conversations sometimes are difficult for business owners, particularly the part where we're sitting here talking about your business assets, all the things that you own and cherish that assist in the operation of your business. Those things are exposed. So, how do you fix it? Layering. Layering. The business should be layered. That means that the ownership level should be separate. And that's separated by the use of the trust, the revocable living trust. That's how it's done. Those assets that are reachable, because the business assets that are reachable, those assets are exposed because they exist at the operational level. They should be titled and held by the holding company. Now, there's a relationship between those two that supports the business structure and upholds the shield, but that's where those assets belong. At the operational level, where we actually do business on a daily basis, there should be no assets there. That's layered protection. But rather than running out trying to figure out how to file more documents, the business owner, entrepreneur, founder, you need to understand how to operate safely. That's the main thing. Understanding how to operate your business safely. What about operating agreements? The documents that were provided to you, or bylaws, if we're talking about a corporation, the documents that were provided to you when you formed the business. Those are the internal rules of the LLC. It's really how the business is going to operate. Voting control, all of those things. What happens if a member wants to leave? How do you value that interest? Documentation regarding placing personal money into the business, capital contribution agreements, loan agreements, understanding that those documents need to exist in order to support the business structure, the maintenance of the business structure. But many business owners have no idea what's in the operating agreement because many have their entities formed by the commercial operations like LegalZoom and Rocket Lawyer and all of those entities like that. And they provide you with a generic operating agreement based upon the state statutes in the jurisdiction in which you operate and form the business. So many people don't even realize what's actually in those documents. And I'll say this to you, if there are multiple members in the LLC or partnerships inside the LLC, comprising the LLC, the business, then you most definitely need to take a look at creating your own operating agreement. Because if and when any of those circumstances arrive, parties want to part ways. How are those things going to be handled? How do you value the interest? How is the voting shares split up? Is it 50-50? All of those things need to be laid out there in the operating agreement. And if you're a single member operating agreement or single member LLC, the operating agreement is still important. People say to me all the time, I've had clients that I've represented say all the time, well, why should I worry about an operating agreement if it's just me, if it's a single member LLC? Well, if you find yourself engaged in litigation defending against a lawsuit and it gets to the point that execution phase where you're trying to make sure that those personal assets are not going to be brought in to play, then that operating agreement, that single member LLC operating agreement demonstrates, it is evidence that the business operates actually as a business. It is one piece of evidence to demonstrate separation between you and your business. If you don't have an operating agreement, that's like going in and confessing and saying, the business is just me. That's what that shows. Where are your rules? Where is the intent to be separate? That's the first document that demonstrates the intent to be separate from your business. And it's probably also the first document to sink you if it's not there. Well, if you didn't even have an operating agreement, how can you argue that the business is separate from the owner? These are the type of things that business owners should be aware of. And we've been having these conversations. And after representing business owners for over 30 years, I have encountered many business owners who want to understand these things for themselves. They don't want to have to pick up a phone to ask a simple question. If someone would only take the time to explain these things and instruct business owners. It's one thing to go and pick up a folder with your Secretary of State documents from your attorney's office or whoever formed it for you. But that provides absolutely no understanding on how to navigate the day-to-day aspects of keeping the assets and the business safe. Those persons who are interested in that concept, I call them the ProSePreneurs. You may be familiar with the phrase pro se because it refers to a person who represents his or herself in court. That's not what we're talking about. We're not talking about the business owner stepping up and representing his or herself in court, although there have been many that have done so. But what we're talking about is the entrepreneur who decides to take it upon his or herself to understand the business structural aspect or the structural literacy behind the environments in which they operate the business on a daily basis. That's what pro se means. It means for oneself. So to take the responsibility for oneself to understand the legal and business environment in which we operate. That's important. That's how we keep the business safe. Now, if you've recognized exposure in your business based upon some of the things that I've described here this morning, if you're operating with a single LLC, if that's all you have, then you do not have business structure, particularly as it relates to your business assets. Those assets are exposed 100%. They're exposed. And there is the possibility, the serious possibility, that your personal assets may also be exposed. That exposure is conditioned upon how you operate the business. If you lapse in and out of moving money from the business side to the personal side, if there is no system in place for payroll or distributions, draws, any of those things, that signals personal. If you're acting as a guarantor for the business, if you're signing on behalf of the business, lapsing in and out personal capacity, then there is the real probability that you do not have any personal protection for those personal assets. It's as if you're operating as a sole proprietor. A sole proprietor has no protection. They didn't form an entity. At least you formed an entity, but you're actually operating, many business owners are operating under the illusion that there's protection when in fact there is none. And here's the worst part about it. You don't even realize that you're exposed until the pressure event arrives. And remember, all of the data that's going to be evaluated is historical data. That means that you can't go back and fix anything. You can't create things. It's important that you understand how to move as you're engaging in transactions on a daily basis. That's what these conversations are about. That's the person that the ProSePreneur is, the person who refuses to outsource his or her understanding of how to operate the business. Because most businesses were built backwards. Nobody ever told you that you should give consideration as to where your assets should be located prior to filing. Not just grabbing an LLC or EIN and a bank account and then going out in search of contracts. That's backwards. Where should I place my valuable business assets? When you ask that question, then you understand that the operational LLC is not the place to put them. They're not to be placed there. If only we knew to ask that question. So there you have it. Now you are aware. Some people are going to act upon the awareness, make a decision to act upon the awareness. Some people are just going to take notes, save the video, and that's what it is. But for those of you who want to take a look at how you're operating the business and whether or not your personal assets may be exposed, we have devised a tool for you to do that. And the link is in the description. It's complimentary. We call it the Structural Exposure Diagnostic. Takes a couple of minutes to run through. There are 5 categories there, 5 sections. It's going to ask you questions about ownership, control, and assets. Basically, these questions are about how you operate, things that you do in the business, how you transact the business, signing things, moving money. It's not about any of your personal information. It's just to get you to reflect on how you're actually operating. And when you go through the exercise, it will score you and tell you where the exposure lives. That's the first step, not to run out and create more documents and gather more documents, because documents do not provide protection. Business structure is about behavior. It's not even a legal situation. It's about behavior because the business encounters a variety of institutions on a daily basis: banks, courts, regulators, auditors, underwriters, insurance, real estate, investors. All of those entities, they don't care about statutes. They care about behavior. And those documents, those signals sent out by each and every transaction, that's the behavior. That's where the behavior lives. And that's what they're reading. So if you're a business owner, a serious business owner, and want to protect what you're actually building, that's where you start. You start with that education, because otherwise, it's like placing everything you built in a single pile. And also in that pile is everything you owe. So when it's time to collect, the people who are owed, they just come in and it's a free for all. Everything is right there. They take what they want, they take what they need, they take what they claim. And all you can do is stand back and watch. You can't even call the sheriff because the sheriff is the one who opened the door and directed them to the pile. We need to understand that. That's how it works. That's how it works. And the protection is built in. If only we knew how to operate. It's built in. Business owners have been using this since the beginning of business. Assets are located properly, names are not on the business, claims are asserted, liability imposed, and the business owner loses nothing, loses absolutely nothing other than the name of the LLC. The LLC gets dissolved, we recreate, reform on Monday, and we do business all over again. That's how it was designed to operate. But you can't do this after the fact. It's so important that we structure properly from the beginning. But if you're operating and you're exposed right now, the next best time to do that is actually right now. If you're not involved in a pressure event, particularly litigation, partnership conflicts, debt defaults, if you're not involved in any of that, you can restructure your business right now. You don't have to dissolve anything. You don't have to sacrifice your employer identification numbers. I get those questions from participants in our program all the time. Well, my EIN number is tied to government contracting work that I'm doing. That's important. If I have to sacrifice that, I can't do it right now. Well, there is no sacrifice. You can restructure right now. Now, the problem with waiting is that the crisis event, the pressure event, it will show up. That's fact. Maybe not today, not tomorrow, but it will show up. And when it shows up, then we get these calls. What can we do? Can we move things around? Can I restructure my business at this time prior to a judgment becoming final or prior to the lawsuit being filed and all of those things? And the answer generally is no. And that's because the other side is going to argue, and it's recognized, widely recognized, that those transactions are fraudulent. They're done for the sole purpose of moving the assets out of harm's way to preclude any claimants or judgment holders from being able to access them. So now you got to deal with the situation and pay the judgment, or the assets are exposed to satisfy the judgment. But if you structure before any pressure event arrives, those assets are protected. So again, if you'd like to take a look at how you're operating your business and whether or not where that exposure is, the link is in the description for the Structural Exposure Diagnostic. You want to answer the questions based upon how you're operating now, not on how you believe you should have been operating, because it won't give you a real answer. And the whole purpose of the exercise is to see where we are currently. That's the purpose. So that's how you want to do that. The link is in the description. You get to download the structural exposure check when you finish. We don't keep the information. You keep it. And if at that point you want to map out your business structure, looking at the deficiencies, talking about where you need to be, what needs to happen in order to structure your business properly, then also in that description is a link to the clarity call. And you'll come to the clarity call with the results from your structural exposure check. And we'll talk about fixing your structure. I hope you guys have a great weekend. Thank you for joining, and we'll talk again. I hope this has created some awareness for you guys.